5, 4, 3, 2, 1. A bare perusal of the aforesaid sub-hyphen rule shows that when the respondent had failed to submit the explanation to the charge sheet, it was incumbent upon the inquiry officer to fix a date for his appearance in the inquiry full stop. It is only in a case when the government servant, despite notice of the date fixed, failed to appear that the inquiry officer can proceed with the inquiry ex parte full stop. Even in such circumstances, it is incumbent on the inquiry officer to record the statement of witnesses mentioned in the charge sheet full stop. Since the government servant is absent, he would clearly lose the benefit of cross-examination of the witnesses full stop. But nonetheless, in order to establish the charge, the department is required to produce the necessary evidence before the inquiry officer full stop. This is so as to avoid the charge that the inquiry officer has acted as a prosecutor as well as a judge full stop. Inquiry officer acting in a quasi-judicial authority is in the position of an independent adjudicator full stop. He is not supposed to be a representative of the department or disciplinary authority of the government full stop. His function is to examine the evidence presented by the department, even in the absence of the delinquent official, to see as to whether the rebutted evidence is sufficient to hold that the charges are proved full stop. In the present case, the aforesaid procedure has not been observed full stop. Since no oral evidence has been examined, the documents have not been proved, and could not have been taken into consideration to conclude that the charges have been proved against the respondents full stop para. Apart from the above, by virtue of Article 311 bracket open to bracket close of the Constitution of India, the departmental inquiry had to be conducted in accordance with rules of natural justice full stop. It is a basic requirement of rules of natural justice that an employee be given a reasonable opportunity of being heard in any proceeding which may culminate in a punishment being imposed on the employee full stop. When a department inquiry is conducted against the government servant, it cannot be treated as a casual exercise full stop. The inquiry proceedings also cannot be conducted with a closed mind full stop. The inquiry officer has to be wholly unbiased full stop. The rules of natural justice are required to be observed to ensure not only that justice is done, but in manifestly seen to be done full stop. The object of rules of natural justice is to ensure that a government servant is treated fairly in proceedings which may culminate in imposition of punishment, including dismissal or removal from service full stop. The proposition can be illustrated by a large number of modern cases involving the use of undisclosed reports by administrative tribunals and other adjudicating bodies full stop. If the deciding body is or has the trappings of a judicial tribunal and receives or appears to receive evidence ex parte which is not fully disclosed, or holds ex parte inspections during the course or after the conclusion of the hearing, the case for setting the decision aside is obviously very strong, the maxim that justice must be seen to be done can readily be invoked full stop.